Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Live Law, where we bring you the latest developments from all courts across India. Let us start. Firecrackers have been a significant concern in Delhi for the pollution they create, especially during the festival of Diwali and other celebratory events. The use of firecrackers in Delhi and other parts of India has been a traditional way to celebrate festivals and special occasions. However, it has also led to severe air pollution and health problems, particularly in urban areas. The Supreme Court today rejected an application filed by the Firecracker Manufacturers Association to include barium with improved formulations in green crackers. The court clarified that the earlier orders passed by it banning the use of barium-based chemicals in firecrackers will prevail. The background of the matter is that a writ petition was filed in 2015 by Arjun Gopal, Arav Bhandari and Zoya Rao Bhasin, who were then aged between 6 months and 14 months through their legal guardians, seeking a complete ban on use of firecrackers, sparklers and explosives during festivals. The Apex Court has since 2015 passed several interim orders while considering the petition. In 2018, Supreme Court had ruled against imposing complete ban on firecrackers but said that only less polluting green crackers could be sold, that too only through licensed traders. Then in 2021, the Apex Court had issued a series of directions to ensure the strict implementation of its earlier orders banning the use of barium-based chemicals in the firecrackers. During last week's hearing, the Apex Court had told BJP MP Manoj Tiwari that it will not interfere with the firecracker ban imposed in the national capital. Although last week the court was considering if the use of barium could be allowed with new formulations, but today the court clarified that its earlier orders will prevail and barium, even with improved formulations in green crackers, will not be allowed. The next update is regarding the recent remarks by Tamil Nadu Minister Udayanidhi Stalin on Sanatan Dharma. Recently, while addressing a press conference in Chennai, he allegedly said, "Few things cannot be opposed, they should be abolished. We cannot oppose dengue, mosquitoes, malaria or coronavirus. We have to eradicate them. In the same way, we have to eradicate Sanatan Dharma rather than opposing it." His words quickly sparkled a political controversy. A plea has been filed in the Supreme Court seeking registration of an FIR against the minister regarding the same. The plea filed by a Chennai-based lawyer B. Jagannath sought a direction enjoining Stalin and others from making further remarks about Sanatan Dharma. The petitioner argued that the conference where the remarks were made had a deliberate agenda to target Hinduism and propagate hatred by employing offensive and derogatory language. Even though the bench initially expressed its disinclination to entertain the petition and asked the petitioner to approach the High Court, it eventually accepted the appeals to issue notice made by senior advocate Dama Seshadri Naidu, appearing for the petitioner. The court, however, refused to tag the matter with the clutch of petitions on hate speech at this stage. In another update, the Supreme Court bench comprising CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra today refused to entertain a PIL seeking an independent audit of source codes of electronic voting machines, that is EVMs. The petitioner Sunil Ahia, appearing as party in person, asserted before the court that the source code was like the brain of EVMs and thus was required to be audited for the survival of democracy. He stated that there existed no formal audit report of the source code in any public domain, and even when he filed an RTI application seeking for the same, the Election Commission of India could not provide him with the report. However, the bench expressed its disinclination towards entertaining the PIL, stating that there already existed requisite security audits for protection in such cases. The bench noted that the matter concerned sensitive policy issues and thus the court would not interfere. The CJI also underlined that source codes of EVMs could not be provided in the public domain as they could be misused by unscrupulous elements. The Andhra Pradesh High Court today dismissed the petitions filed by former State Minister and Telugu Desam Party leader N. Chandrababu Naidu for quashing the FIR in connection with the multi-crore skill development scam case. Naidu, as you know, was arrested on 9th September by the State Police's Crime Investigation Department, that is CID, in connection with the scam. Naidu's application before the court stated that the trial court's order sending him to remand was passed without taking into account the fact that the CID had failed to obtain prior approval from the governor in accordance with Section 17A of the Prevention of Corruption Act. But according to the court's verdict, no prior approval from the competent authority was necessary for investigation, as use of public funds under the color of authority but really for his own benefit could not be considered as an act done in discharge of his official functions. Also, the court agreed with the state on the fact that the investigation was at a nascent stage and should not be scuttled with. It said, in instances representing serious economical offences, the approach has to be different, more particularly when the investigation is at the initial stage. Marital rape is a highly sensitive and controversial issue in our country. Not being illegal, it refers to sexual intercourse without the consent of one's spouse within a legally recognized marriage. Adding to the ongoing debate regarding the criminalization of marital rape, the Madhya Pradesh High Court has observed that after the 2013 amendment to the definition of rape under Section 375 of IPC, there is no place for any unnatural offence to take place between a husband and wife. The court made this observation while quashing an FIR lodged against a sitting member of Madhya Pradesh State Legislative Assembly by his wife, alleging inter alia a commission of unnatural offence as per Section 377 of IPC. The court said that as Section 375 includes all possible parts of penetration of the penis by a husband to his wife, and consent is not required when the sexual act happens between husband and wife, any unnatural offence cannot be made out in such cases. Importantly, the court also stressed that the relationship between the husband and wife cannot be confined to their sexual relationship only for the purpose of procreation, and therefore, if anything is done between them apart from the deemed natural sexual intercourse, the same cannot be termed as unnatural. In other words, the court reasoned that in a given case of rape, if the offender and victim are husband and wife, then consent is immaterial, and hence, and as such, the husband will not be liable for any punishment under Section 376 of IPC. The Supreme Court has made some significant observations with respect to Tamil Nadu Tamil Learning Act of 2006. This act made Tamil paper compulsory in the 10th Standard Board exam. As a result, while Tamil was mandated as a compulsory subject, minority linguistics were considered as an optional subject for which there was no requirement of minimum marks obtained. The Apex Court was hearing a plea challenging the order of Madras High Court, where it refused to quash a government order of September 2014, bringing all the schools in the state under the purview of Tamil Nadu Tamil Learning Act. This meant that languages such as Telugu, Urdu, Kannada, Hindi, Gujarati, Arabic and Sanskrit would no longer be part of the school syllabus. The core issue before the Supreme Court bench, comprising Justices S.K. Kaul and Sudhanshu Dholia, was whether minimum marks can be prescribed for minority linguistics as required for other subjects, including Tamil and English languages. This prescription of minimum marks was sought by the petitioner, Linguistic Minorities Forum of Tamil Nadu, in order to obtain proficiency for minority linguistics as well. The court held that while proficiency in English and Tamil is required, However, to protect the interest of minority linguistic institutions and the minority linguistic followers, similar proficiency is needed in their mother tongue language, even though as an optional subject. And thus, minimum marks as provided for other subjects will also be provided for the mother tongue and reflected in the mark sheet. In another update, the Supreme Court today issued notice in a contempt petition which alleged that the Union Government, the State of Kerala, and the Kerala State Commission for Backward Classes, that is KSCBC, have not complied with directions to conduct socio-economic study for revising the reservation list for socially and educationally backward classes in the state. So the petitioner has stated that in September 2020, the Kerala High Court had directed the Union Government to finalize the socio-economic study report and to identify socially and educationally backward classes in the state and submit the report to KSCBC. The KSCBC, on receipt of such report, was directed to make recommendations to the state. And the entire process was to be completed within 6 months. Further, the Union Government challenged this before the Supreme Court. In June 2021, the Supreme Court dismissed Union's SLP, but an additional time of 1 more year was granted to comply with the High Court's direction. Now the petitioner has alleged that despite the lapse of the extended time, the directions have not been complied with, and that due to non-revision of the reservation list, the Muslim community, SC, ST, and 70 other backward classes were grossly underrepresented in the Kerala public services. Today, the Supreme Court bench comprising Justice B.R. Gavai, Justice P.S. Narasimha, and Justice Prashant Kumar Mishra has issued notice in the matter. Stay tuned with us for further updates. And lastly, the Calcutta High Court has granted interim relief to recruitment scam accused and Trinamool Congress leader Abhishek Banerjee by ordering the Enforcement Directorate to not initiate any coercive action against the TMC leader arising out of the files which were allegedly unauthorizedly downloaded from a company linked to him. Let me tell you, during the pendency of the present quashing plea, ED had raided a company named Leaps and Bounds and had suggested that large sums of money linked with the recruitment scam were being funneled through the company in which Banerjee was a CEO. But Banerjee's lawyers had argued that the seizure of 16 files made during the raid by the investigating agencies was wholly illegal and without jurisdiction. Due to this, the court had earlier deferred delivery of its verdict in the matter. Previously, ED had submitted before the court, assuring that they would not use any of the content of the files against Banerjee in any criminal proceedings. Today, after arguments were concluded in the quashing plea, Banerjee's lawyers approached court apprehending that the ED would take coercive steps against him. Accordingly, the bench directed ED not to initiate any coercive steps, but held that the ongoing investigations against him could continue. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.